So if anything, Tim, it seems like we want the center one to be, the other camera to be mostly on them, not on us. The center camera being everybody, but I'm fine with doing it either way. I just want to make sure we have a camera focused on them.
Okay.
I think last time we did one here, this, and then one there. I know I told you the center thing, but if we can do the center, we need to have one there and one there. If we're going to do the center thing.
I'll move that one.
Honestly,
Oh, you moved that one? Okay.
I'm not fit. Wildcat. We already have a phrase for it.
He said I should talk to Dr. Parrish and review what consensus means. I said consensus is great, but you can't always lead by consensus. Sometimes someone has to make a decision.
Yeah.
You know, if everybody knows they're in a consensus environment, you have a bad actor who use that to manipulate the conversation. At some point, you have to have someone who's in charge. You know.
Yeah. I'm okay with that.
It looks okay now. Okay. Nice. Sounds good. We're really short on the front row here today, guys.
Well, where's Jeremy?
Couldn't make it
He
today.
needs his warm body up there. Being all tall.
Jeremy's gonna take 3 vacations a month, so you know. Jeremy's always on vacation, so.
Oh, I was thinking it's can't work.
A lot of people won't be able to make it because we pushed it back.
Vacations.
I like that.
But when he's not vacationing, he's working.
I feel like I'm never working for money. You know what I mean? Here's all my free time.
If we have time, this is where the trail starts. He sent me that today after the meeting. Maybe that was a little rough. I don't know. Probably was. A little rough.
He told me to check the deal. It's so good.
Who told you to check it out?
Everybody do.
Just whatever.
Pokeballs?
If David doesn't want it, I don't. That's kind of what I was told.
Well, then no.
No. That's what I ordered. Pokeballs.
No. Well, both are delicious right now. I'm out. So good.
Let's do that on here. Should I Pokeballs today?
Is that what that?
Same in the
It's delicious.
You give it a chance, you can get some comfort biscuits, Cracker Barrel or something. Biscuits and gravy.
Actually,
Yeah. That sounds good.
sounds good.
Cracker Barrel. I'm just kidding.
I had a big old chicken fried steak. Doing specifics, Tim, or just a big random one?
Random water. That work?
Yes, sir. It's great.
Morning. I switched it over to your side in case you
Oh,
wanted to
okay.
start up.
Sure.
I think we're alternating or something.
Yeah, that's a good idea. Make sure we're on the same page. It's actually been pretty helpful to do both of them.
Oh no, it's the other thing again.
Yeah, that's okay. I actually prefer it. All right. So today's the 7th, your session is 6. And this hasn't changed. We still have our dates coming up. The next one being Monday, and then next Thursday.
It's Friday.
Friday.
I'm sorry, you're right, Friday. The 10th is Friday, and then the 13th is Monday.
Okay.
And then the 16th is next Thursday. Yeah. And then 23rd, 24th, and the 28th so far. And then our dates here in July, which I think we'll probably nail down whether we do the full week as we get a little closer.
Yeah.
This is what I have as key 8 articles to date.
Let's see real quick. Just compare three.
Sure. The only one that we added would have been 3 from last time.
Right. 20, 29, and that's what I showed you.
Okay. This is what I have as proposals received from y'all, and it includes some that have been TA'd, of course, and doesn't really distinguish which side of the table. It's not just what we've been working on. Same with the city of Austin, and we're gonna propose or respond to some articles today as well that will eventually get added to this list for next time around. But again, also includes stuff that's already been TA'd and doesn't distinguish which side of the table it's on. I believe these, and you can correct me if I'm wrong on this, but I believe these are on y'all's side of the table. We had some discussion about it, at least for sure about 26 last time, and you proposed management rights.
So I got management rights 7 is correct. I'm showing wages just because we did the conceptual, but you know, it doesn't really, it's kind of, doesn't matter.
Yeah, that's fine.
Cadet, and hire agreement, and that's what we show also.
Okay, great. This is what we are going to be presenting to you today. Article 11, shared communication. I believe, you had made a comment last time that I think we're pretty close, so we took another look at it. I think we are pretty close, so we'll go over that. We'll have responses for Article 17, Article 28, Article 30, and Article 31 as well.
And so we have another response on Article 31 based on the conversation we had,
Okay,
and we can do it in any order you wish.
okay, all right, sure. Yeah, I know that last time around we had discussion about a majority of articles, and so I'm not surprised to hear that y'all have.
Yeah, well, with Matt here, he came with some wording we think meets your interest, but, we'll see.
Oh, Article 8 needs to be on there on this list as well. We'll be proposing Article 8 as well.
If you're gonna do what with 18?
Article 8
Okay.
needs to be on this list.
Okay, and we've got a, suggestion on that one too.
Oh,
So,
okay,
it might make things simple.
great. So pending articles with no proposals from either side, Article 2, save until the end, Article 18, Article 19, and Article 24. I took wages off there because you gave us a conceptual proposal.
Yeah.
Articles being actively discussed. We've added some more since last time, just since we've had some conversations about it. Article 26, 30, 31, those are all articles we discussed last go around. I know we'll be most likely, hopefully TAing 11, but it's still on the table in terms of discussion.
We're pulling Article 7 out of conflict.
Out of conflict?
Yeah.
Okay.
So just so you know.
All right, good to know.
Yeah. Thought that'd make everybody happy.
Forward progress is progress, right? And of course, well, we've always, remained committed to working out a deal. So that's our summary here.
You want us to do our side?
Yeah, go ahead, unless you prefer us to, yeah, you go, that way we can see if we're on the same page. I think we are.
So I just went through my side, I think 10 agreements, we have the same, I want to verify. Just those. I have shared communications soon to DTA, I might be wrong, we'll see what the conversation takes, but I thought we were really close, I just kind of kept it in that other category. I wanted to talk about the information request. It's been some time since we put it in, and some time since we've heard any response back. It's been 2 weeks as of today. And so, let's try to download it. I was having trouble doing that. I will just send it to you, I guess. Maybe it won't pull it up quickly. Yeah, so, you got a copy of it, I'll resend it to you. There were 6 items we requested 2 weeks ago.
Okay.
And then there was one item we kind of talked about, last one was the calculations for how longevity is being handled under Fair Labor Standards Act rule or regular rate.
And I will tell you, the one that you sent a couple of weeks ago, I didn't realize it hadn't been responded. We pushed it out to the appropriate departments, but we'll follow up on that.
Okay, thank you. I'll resend it today. Sorry, I thought I could pull it up here, but
That would be great.
couldn't. And we show on the management side, civil service. I think we had a discussion about that at the table. And I actually think we have some wording from Matt that may be helpful, but I think you showed it on your side of the table also, didn't you?
Yes, we do have a proposal for 18.
So we can probably do a back and forth on that one pretty quick once we start talking about it. ABL, leave, hours of work, overtime, promotions, hiring and training, hiring and cadet standards and savings clause. And then we'll respond to today, management rights, dues, cadet, and entire agreement, maintenance of standards, and merger. And we have some language that Matt listened to you all on that he realized there were some legitimate concerns y'all had on your side of the table, and we think we have something fashioned that will satisfy a lot of them, maybe not all of them. A lot of them. Wellness we're still working on, and I think we have the same ones not brought up yet, definitions, discipline, and use of civilian employees. And just to let you know on discipline, I think it's going to be mostly some process changes that we agreed to, through policy, and then a couple process changes I think we didn't agree to, we'd like to discuss and perhaps add, but we're not looking at gigantic changes to that article. It's more those type of items. So. And use civilian employees, honestly, we just haven't really taken a close look at the article yet. So we don't like to have a big, bomb drop on that one or anything, I don't think. We just haven't really had a chance to go through it. And we took dues off of conflict side. So that should bring some smiles, happiness, joy, contentness. And that's it.
Okay. Did you want us to, let's talk about 8, since I think we both have proposals.
Yeah, we could, I don't care who goes first. You want to go first?
Yeah, sure.
Okay.
So, kind of we're trying to keep track of the history of the proposals going back and forth, and so the first section in red would have been y'all's proposal back on 5/16, and our counter proposals. And so this was Matt's inclusion last go around. We still had an issue with it in terms of no, in terms of a city attorney, and any assistant city attorney being able to discuss with their supervisor, a city business, city legal business and things like that. Obviously, so our position basically is ex parte communication, the way it's already worded, seems to cover the issues that y'all had raised last time. So the parties agree that neither the city nor the association shall have ex parte communications with any member of the Civil Service Commission concerning any commission proceedings such as disciplinary, appeal, promotional bypass. I mean, the term ex parte covers that concern, like the definition of in and of itself. We already have, as attorneys, we already have an obligation to comply with the Texas rules of disciplinary procedures. We already have, we already have that, those, and we already have to comply with ethics, with the ethics of the city. So basically, I think what all this discussion is coming around to we really would like to leave it status quo as is. And so you'll see that here.
I think my concern is Matt's wording seems to meet all the interests you just described. Why would we be reticent to accept that? If that's what ex parte communication is, and that just makes it more clear in the context of this particular office, why would we not want to adopt that? What disadvantages there in adopting that to y'all?
Well, so Matt's language seems to go a little more broad than that. Any city attorney acting in an advisory capacity to the commission will advise the commission in accordance with the attorney's professional judgment. I mean, I think that's already, but it says regardless of the city's interest in the matter for which advice is provided. It doesn't provide any parameters on that. No city attorney acting in an advisory capacity to the commission will coordinate with any other city attorney or other city employee to persuade the commission to adopt the city's position on any matter before the commission. So no city attorney acting in an advisory capacity to the commission will coordinate with any other city attorney or other city employee to persuade the commission. That is already covered in ex parte communication, but I think this is, I'll be honest with you, some of Matt's proposals are a little more wordy than they need to be, and maybe that's the lawyer in us, I guess, but our position is this is already covered in the current language just by the term and the use of ex parte. Adding this additional language could construe, what we're afraid of, honestly, is that this blocks the ability for a city attorney to discuss with their supervisor, to consult within their own department. I mean,
It gives an implicit right to discuss with the commission on behalf of the commission's interest. They just can't coordinate with other attorneys.
Well, moreover though, the phrase regardless of the city's interest in the matter for which advice is provided, that goes beyond advocating for a particular case, and that goes against the ethical violation of any city attorney. Flat out, it's against the state bar ethics. You could file against an attorney who followed that rule. That would be against their professional ethics. They work for the city. It is a city commission. They don't have to advocate. We understand that you don't want them advocating the case or coordinating with the attorney who's, to kind of come up with a little bundle to tell the commission what to do. We get that. But that's covered by ex parte communication. What you have us saying here can't be done. It can't be done under professional ethics.
Then why not add it?
Pardon me?
Then why not add it if it can't be done?
Regardless of the city's interest in the matter for which advice is provided, that in and of itself is something that can't be included, because that phrase itself is against the city attorney's ethics under the professional standards.
Yeah, an attorney has to take into account their client's interest and provide that legal advice.
The client in this case being
The cities.
okay, well, that's the problem. Right?
Well, yeah,
Because the
but,
client should be the commissioner.
well, the client is the commission, but the city attorney in the city attorney department wears multiple hats, right? So it's taking into account the city's interest, yes, but the city's interests are going to also probably be in line with the commission's interests. So, I mean, I know what you're saying. I know you're saying that obviously we're not going to advocate one way or another. Like you've got a disciplinary hearing before the Civil Service Commission, and the city attorney who's assigned to give legal advice to the Civil Service Commission is going to tell them what's in the parameters of what they can do under 143 or the contract, right? And we get that the goal is to not have that attorney assigned to give legal advice to the Civil Service Commission, say, oh, y'all need to fire, keep this person fired. That we believe is covered in the language already here. By adding this extra language, what Sarah was saying, regardless of the city's interest, that could be construed as something that would violate our own ability as attorneys when we're representing our client.
See, that's where I'm having more problem with it now than before.
Does that make sense?
Because it seems like the client in this case is not the city, the client is the commissioner that has the legal question.
Yeah, that's against Ethics 101 at city attorney seminars that we are mandated to go through every year and keep up our CLE credits with the ethics in there. Ethics 101 is who is the client. And every city attorney will tell you that we are trained specifically as city attorneys. The client is the city. It's not the mayor, it's not the city council member, it's not the commissioner, it's the city itself. And that's just Ethics 101. And Matt probably doesn't go to city attorney things, but he can tell you that more specifically as what we're actually saying. The client is the city as a whole, not the citizen, not the commissioner, not the mayor, not the city council member. It is the city. So that phrase right there is very problematic to any city attorney.
Okay. Well, I'm not an attorney, so I'll take it back to our attorney and we'll take a look at it, but it just gives me a little concern. I'm probably not understanding it correctly, and I'll grant you that's a possibility. But to me, the client in this context, what we're trying to say is the commissioner. And you're telling me we can't do that, so that's important to know if we can't do that. But then how do we, let me ask this one last question. Sorry for these questions, and some of them may not be, if I was an attorney, I may ask them differently. But if the city attorney's client is the city, then what obligation does that attorney have to promote the city's position? And how does that relate to, how does that compare to the concept of ex parte communication? So can they relay items that are in the city's interest to the commissioner?
Well, you have to understand what the city's interest is as a city attorney. And that's not necessarily what action a fire chief took. It's the ultimate liability of the city and whether or not the action was appropriate under the laws and under the contract. And so I mean, it is the entire ethical situation a city attorney is put into, and it is covered by the Code of Professional Standards. And they have to understand who their client is and how they can relate all of that to. And we have run this all through the legal department to make sure that we're correctly expressing their opinion. So, I mean, it is a difficult concept, and that's why city attorneys are trained on how to determine the interests of the client versus if the mayor or the city manager does something, just off the wall that isn't in the best interest of the city as a whole, then it is the city attorney's duty to point that out. So it's not like I'm protecting the fire chief because that's the city. The fire chief isn't the city. The city is the city.
I understand.
So it is a.
In this case, the commissioner's trying to get legal advice. It should be pure and not tainted by
Correct.
a city's position.
Yes.
Well, city's position is the legal position of following all of the rules, etc., not the city's position as the fire chief. The fire chief isn't the city.
I understand that.
So the city's interest lies in that each department, each commission are doing things legally. And so there's policy decisions or there's going to be factual disputes that they are going to resolve as the commission. And then the goal of the legal department is just to make sure that they're following within the parameters of 143 specifically, or the CPA, whatever's in the CPA. So the interest, I guess, is not necessarily that this person stay fired. It's the interest is that the law is being followed, and whatever the commission decides, that's on the commission. They're going to be the ultimate decision maker in that scenario.
Okay. Well, I think I got enough on tape. We could review it and in terms of look at it. I appreciate you guys being so candid about it.
You did say you had also some language that did I miss?
It was on cadet, I think. I might have said civil service. I meant on cadet.
Oh, okay. doors close, and so my memory is that, so we received a proposal on 516, we provided a counter proposal with some additional language, and then we also requested, you know, some follow-up communication on C specifically, and the language that y'all had proposed if overtime would normally be paid to other participants at an AFD committee meeting. AFA representatives will also receive the same benefit. So I know we had a lot of conversation with that, and based on that conversation, we still don't feel there's any issue. We'd like to leave this section as is. So our counter proposal today is to strike that. I think we are in agreement with section 3A. That's been also struck by y'all in y'all's proposal.
So explain to me how that's not discrimination. So if you and I both get off at noon, and you're invited to meeting in the management side, and I'm invited to meeting, let's say I'm on shift duty on the association side, and they turn around an overtime sheet, and you sign it because you're on overtime, and I'm not on duty, and I can't sign it. Explain to me how that's not discrimination.
Discrimination in what sense? Like
The sense I just described.
Well, okay, so I guess my question is how has this been an issue in the past? My understanding is that we don't ever have that problem that you're
We have
anticipating.
that problem all the time. We're trying to bring it up now as an interest. That problem happens frequently.
That other folks are getting overtime when some are getting overtime and some are not.
Yes. They're at the same table, they're the same invite, but if you're in the association, you're being discriminated against because you're not receiving overtime, even though you're invited,
Oh, so you're
and
saying
the other people are. So how is that not discrimination in the association?
so you're saying that association members are being discriminated against?
Their affiliation with the association, yes, because they're invited, you know, the management said we need somebody from labor to be there. They consider them an important stakeholder. I bring somebody, if they're not on ABL, then they're off duty. When the overtime list comes around, they're not allowed to sign it, even though you would be. For the same meeting, same invite.
So I think maybe, our position stands as you stated it, that maybe if you want to reassert something different in the way you're describing invitation and who determines who has to be there, if there's an invitation for a labor representative and you're the one who determines who the labor representative is, and that person happens to be off duty and you're the one who selected them, versus, you know, them telling somebody else in management, you have to be there, John Doe.
Yeah, I mean,
You know, and I know your schedule, I'm telling you, you personally have to be there versus you determining who goes. So maybe if you restated it in a different way that where, you know, instead of invitation or, you know, because it just seems like it's not quite jiving with our understanding of what's happening.
Yeah, and I think currently, if we include your language here, and you compare it with the current language there, finally, it is the goal that the association locates and assigns association representatives. If we start adding this overtime component, there's no limit to who's located and assigned as.
Or how many.
Or how
when I
many.
laid it out, we said that it was in the fire chief's purview to decide who's invited. We can add that to the wording.
Yeah, why don't you change the wording a bit so it's a little more clear, because the way it is not something that we can accept as is. But I understand the problem we're trying to get to.
Okay.
So, and then the last part dealt with the ethics policy, and I know that we had sent you a copy of the ethics policy. Hadn't heard anything back, or if you had any additional questions on it. So this seemed to be the last section that was still under discussion. So if you're fine with this,
I think it's fine, but there's certain things, I believe it's fine. Let me ask you this question. The ethics policy doesn't really contemplate online voting at the fire station, you know, but I guess that'd be under de minimis computer use, I guess. So that what would happen is, and it seems like the policy is broad enough to include this, but, you know, a person may look at the discussion board at the computer station on a particular upcoming online vote, and he may add a comment to that. And then when the voting period comes, he may vote on the station computer. That's the kind of, you know, he may watch this video, you know, at the station computer. In fact, I think people are probably doing that right now. There's probably people right now on a station computer that if they have downtime, looking at what we're talking about at this very moment. We want to make sure those activities are fine. You know, we don't want to just say, yes, the ethics policy was good, and then someone says, wait a minute, you can't be looking at videos, you know? So those are the activities we're talking about, pretty specific. We're not asking for anything more than that. Occasionally I have somebody to print out something and put it on the kitchen table. That happens probably on the average less than once a year. And it's usually a couple pages, it's not like a ream of paper. It seems like sometimes people pay attention to more things that are sitting on the kitchen table than they do on a computer. But the type of things we're talking about. So I read that and I say, yeah, that's probably fine. I'd like to know if y'all think that's probably fine based on that ethics policy.
Well, I think that probably a majority of the stuff would fall under the de minimis, but I mean, that's also a case by case basis, and then the ethics policy is not gonna have every single tiny scenario because then it's just gonna exclude others. So I think it would just require a closer look at the ethics policy to see if what you're talking about. I mean,
because we'd be fine with that
likely-
section. If you came back and said the items you listed just now, we feel fit under the ethics policy just fine. Mostly what they do. And we're good, you know, but we're going to this construct called the ethics policy, that's fine. It's good that we're doing it, but I just want to we have real examples. We want to make sure that within that policy assessment.
Well, and I do think it's our position that you're already bound by the city ethics policy. We're not adding that to what you're bound by. We're just delineating it here so that you have something to refer to when you're looking at this.
Yeah, we're not questioning that.
Okay.
We're just questioning, since we're at the table talking about this right now, do those items I just discussed fall under the ethics policy? And I believe they do. I just want to make sure you all believe the same thing.
okay. Oh, wait, no. Let's see. Go to 28. I actually think we're closer on 28 than any other ones that we are discussing today.
Yeah, that's fine. Tough one. Okay.
So we looked at Matt's language that y'all proposed last time, and it seemed that, well, it didn't seem, he did agree, it seemed that y'all agreed with the proposals that we proposed. And so his proposal accepted the changes, so they don't show as changes anymore on his end. So we added them back in just so we're all keep track of what old language is or current language is compared to proposed language. And so everything in the first half up here, or the application of such provision in red, invalid by reason of, that was all accepted. Legislation or judicial authority, that was accepted as deleted by Matt as well. So basically, lines 5 and up were all agreed to by Matt. There was another sentence where he basically, this is where it kind of got wordy, where he added basically, let's see where, it's kind of hard to read. If any provision of this agreement or the application of such provision is subsequently declared invalid by reason of any existing or subsequently enacted legislation, he included that sentence again in the middle. I don't think it necessarily needs to be there, and again, I think the parties shall meet as soon as possible to agree on a substitute provision. It's all in the same article, I don't think it needs to be that wordy, basically. This second half here, if the parties are unable to agree to a substitute provision within 30 days following the commencement of the initial meeting, then the matter shall be postponed until collective bargaining negotiations are held. He agreed with that sentence. If the parties agree to a substitute provision within such 30 days, he included some language following the commencement of the initial meeting. I didn't include that because, again, I just thought it was a little more wordy than it needed to be. Adequate time for ratification shall be granted. In a sense, end of the day, it appeared that the AFA had accepted the majority of the city of Austin's language, subject to us kind of making it a little less wordy than the last proposal. So if y'all want to take a closer look at it,
Yeah, we'll take a closer look, but it does look pretty in line with what you're saying. And what we showed our last proposal. Now, what was the problem? our edits, our track changes didn't show up on your copy I sent you?
Yeah, so let me see if I can find.
We didn't intend that. I thought I sent it properly.
It appeared that he had accepted the change,
Oh.
accepted insertion, and then we saw only his edits, which,
Well, we don't mean to do that. so I'm sorry.
no, and I think the intent was just to see his edits and not a combination of both of ours, so maybe it was trying to actually make it simpler. But, I don't wanna confuse proposed language with current language.
No, I agree.
Yeah, and when we eventually propose it to city council, we show it completely redlined. So when he does that, he's trying to be helpful, but it winds up we have to undo it and retake it back in.
Yeah, I'll mention that to him, because we don't, I think it should all be
You
on
don't
there.
do it that way, yeah, so, yeah, if you would mention that, that would be very helpful.
Okay, I'll talk to Matt about that.
And I don't recall if this was, one of the ones that you said you also had some language, or if that was 30.
26, I think it was.
26, okay. So we had talked at length about this also last time around. So we had received 2 proposals from y'all, so we're just trying to kind of keep that historical background, and data. So the AFA proposal received on 6/3 is footnoted. This here is on 5/23 that we received from y'all. This is y'all's proposal, that we struck out in red. And then just to not make things so confusing, the proposal we received from last week, we included down here in a footnote. And we also included the explanation that Matt provided, just for kind of everyone, trying to keep track of the proposals and the counter proposals and the proposals and counter proposals. So that was, this is actually y'all's last proposal here.
Okay.
And our proposal has stayed the same. So when we provided a counter proposal on 5/25, our proposal is still the same. We do not think it's bad faith bargaining to decide whether or not we want to engage in an evergreen period at the termination of the agreement, or the continuation during negotiations. Now, we had also discussed that we can change this to, instead of 30-day calendar increments, we can at the mutual consent of mutual written agreement by both parties, we can change it to be up to 6 months, so we don't have to do the 30-day increments. We're open to that, but we still want it to be by mutual agreement of the parties. So our footnote kind of just explains, just again, the history here. So we want to also maintain our right to all of our legal rights in the bargaining process. And I don't think this is inconsistent either with the stipulation agreement that the city has signed in regards to binding interest arbitration.
Okay.
For this, I know y'all had provided a proposal that basically struck this out and provided for a reopener. I think we're still willing to discuss this section, but we do not want to have a reopener provision. Anything additional?
And so who triggers that language again at the bottom for the change in wage?
City council.
And so if we reach an impasse, I don't think there's any doubt at this point, the current environment, we're gonna go to interest arbitration. One of, either will compel it or the city will compel it, but either one's compelled, then we go to interest arbitration. Why don't we wanna put that in there?
Going to interest arbitration.
Yeah.
Well, because I think that's still, we've already got it in the stipulation agreement, right? We already agreed that we're gonna go to binding interest arbitration. but we still want to retain all of our legal rights and arguments because of the fact of the outstanding legal question that has currently been accepted by the Texas Supreme Court as of last week.
Right.
So I think that's all been covered in that stipulation and agreement for both sides.
Yeah, I think it has too. It just seems like to us, we think it's important to put it in here just so it's clear, and I think you guys look at it as kind of, maybe we're trying to, or maybe you would, regardless of what we're trying to, or our motivation is, hurt your legal position.
It's not that it would hurt the legal position.
Okay.
If it's put in there, then it would be outside of that whole thing. It would be in the contract regardless. And if
Okay, that's helpful. That's the way you guys are viewing it, and maybe that's the only way to view it, but we look at it differently than that. Maybe
Yeah.
that's part of the problem.
we do not think that it should be referenced in the agreement itself at all. It is not in the San Antonio agreement, it's not part of the agreement. It's a remedy if you get to impasse on an agreement. But it's not, as you described in one of the sessions, I think you said it's a new way of dispute resolution. Well, that's just flat out not true. It is only.
What did I say? I'm sorry.
It is a new method for dispute resolution, and that is not true. It is only a method for dispute resolution in the case of impasse on the collective bargaining agreement, not for individual subsections of the agreement as we move on. So the way that you're articulating it is not how we believe that charter amendment
How is it not
is
a
written.
new dispute resolution for us? Since we've never had it
It is-
before and it's new.
It is a new dispute resolution in the circumstance as described in the charter, not for every little section of the agreement. It's not a brand new dispute resolution for every single thing in the agreement, only for an impasse of the negotiation of the agreement itself. And that's how that charter amendment is written. So to continue to insert it into each section, to us, is nonsensical.
Okay, that's helpful, because we look at it differently, and it's good to know how you guys look at it, so that's
And I
that's
think,
helpful.
and specifically to this article, it appears to me that based on y'all's last proposal in 6.3, that y'all have come off including the charter language in this particular section 2, and just want an automatic continuation of the contract. And so I don't want to take steps backward either.
Right.
Because it seems like y'all had made steps forward into our direction, and I don't want to go 2 steps backward now. What we're wanting in this particular article is just that each party, we can agree to extend the contract while we're in the middle of negotiations, or while we're continuing to do whatever process that we're gonna do, whether it's binding interest arbitration or mediation or whatever.
But agreeing to that does not stop the charter amendment as long as it's continued to be constitutionally.
And by
Is
mutual,
that your position?
and we will agree to extend the contract so long as it is a mutual agreement between the parties, not just something that's automatic. We want to be able to say yes or no, we're gonna agree to extend this contract. Is basically what our position is.
Okay, but that doesn't affect us, our ability to take to binding arbitration.
Right.
Okay.
Well, the signed agreement it covers all of that.
And maybe that's what our concern is, which is opposite of your concern. You know, we're just concerned if we don't put it in, there might be some question about it. And I guess your concern is we do put it in, then it goes beyond what the city charter actually could be interpreted as going beyond what the city charter says.
Yes.
So that's helpful. We're really not trying to write it in, believe it or not, but I can see from your perspective why you think we are. And we're trying to figure that piece out, so.
And to touch on what Sarah just said, I mean, there's other articles that mention in the contract that, in your proposals that mention the charter amendment here. And it appears that instead of this charter amendment being used for when we would go to impasse in the collective bargaining process, it's starting to look like it's being used as more of a dispute resolution for individual articles.
Yeah, well, there's certain things like the individual article of merger, which we would like to use it for that. You know, and I think there's good arguments that you could say that's outside of the charter, but we would like to use it for that. And that's clear. I mean, I'm not trying to say that's part of the regular charter amendment.
Well, and I think in our response to the merger language, that is our position, is that we do think it's outside of the charter and that we do not want it written into the contract. So, agree to disagree.
No, I can
You
see
know,
your argument
and
on
at that
that one.
point, yeah, so
Clearly,
that's-
we are trying to add it there.
Yeah,
You
yeah.
know? I don't think we're trying to add it in other places, although I know that looks like that to y'all, so we'll figure
Yeah.
that piece out.
Yeah, I think as a general position, we don't want it mentioned at all in the agreement proper.
Correct.
As is a resolution to not coming to an agreement, as opposed to part of the agreement.
That's helpful. Appreciate it.
Charter's stronger than the agreement typically.
No, that's good to know. It's just, sometimes it's good to talk these perspectives through, because I don't think we're doing maybe cynical stuff we think we're doing, but it may look like that, and so, and vice versa sometimes. So it's good to talk these things through.
30, since we just talked about this is, we put your proposal in here, and you read it, of course. Small.
So you're going back to original language.
We're going, yeah, that was our initial proposal, back in 525, and I know we had a lot of discussion about it last go around. And again, our position remains the same. We wanna leave it the status quo. Yeah, we just don't believe that the charter amendment is appropriately characterized by AFA as a new dispute resolution methodology as we just discussed right now. And I know that you said, no, we are trying to put it in here, so, and that is, I mean, we've already discussed this.
Now, Matt might feel differently. Matt might feel that it is part of the charter, but I'm not sure with my current perspective. I agree with that. I think it's something we ought to add.
All right. So now we're down to Article 17. It's not showing up on either screen.
Go back to where you were and click on the document versus the document.
It's not showing up on either screen. Let me just unplug my computer real quick so I can report it. All right, so hiring and debt training. So section A is some new language that we added. And basically it's, I would call this more legal language. We recognize the cities need flexibility in the hiring process. We're deviating from 143 to the extent of this specific article. Otherwise, we're gonna follow 143, is essentially what that says. So adding section A had a kind of rippling effect on the other letters. So screening and testing applicants. So what you're gonna see here is, and I'm just gonna jump around and sort of explain a little bit, right? So we've added section C and we've added section D because our proposal includes eliminating and striking this entire section B of the HPOC Oversight Committee. And I'll get into some of the reasons why in just a minute, but here's essentially, this is the language that we're proposing. So the fire chief will develop and implement screening and testing procedures used to determine whether an applicant will be offered a position as a cadet in the AFD training academy. So The screening and testing procedure will include at a minimum a structured oral interview board and a background investigation. Nothing in this agreement or one further restrict the nature of the tests administered to applicants or the procedures used to administer this test. Applicants who successfully complete all the screening and testing procedures will be placed on an eligibility list per department policy. So the only thing that we really salvaged from the HPOC section is the ranking of the eligibility list. Because that, obviously, we need to explain how we're ranking it. So some of the issues that have popped up with this vendor selection and the vendor process, and I know that Devin had mentioned in 2015 that all this rigmarole, all this XYZ would actually limit the ability of some folks to be able to submit for the RFP process. And I believe, and you can correct me if I'm wrong, but my understanding is that there's only been one vendor who's been selected to do this process in the past 10 years. And so I also wanted to show.
Pretty close. Yeah.
You're right.
Maybe a little less than that, pretty close to that.
And
But it wasn't, there was only one qualified, there was just one selected.
well, and then, so we've had some issues that have popped up because of all these specific requirements in this contract. So I wanted to just show one email where this particular vendor just did not have the ability. I cannot see how to maximize this. And this came from, just some feedback that came from purchasing. Let's see what the company is. IO Solutions.
We used them before this vendor.
You used them before.
We had an incredibly undiverse process. And it resulted in a consent decree because the test was not given the right amount of time. I'm very familiar with the work. I just don't know that we should be hiring them for our next hiring vendor.
And I'm just showing you some of the issues that we've had and feedback that we've gotten from the vendor in the hiring process, and wanted to highlight some other feedback that we got here.
Can you send these to us?
Yes, of course. Can the vendor provide criterion-related validity evidence to support or justify the use of specified assessments? Claims of criterion and related validity should be supported by the provisions of a validity coefficient and the requisite information and data that went into the generation of the specified coefficients. And then the city's response, we see that your offer referenced validity, but evidence wasn't provided on how the validity is achieved. And so this person provided an explanation as to how the validity was achieved. And these are just a couple of the issues that have come up in the vendor selection process. And so the city, and I'll be honest with you, as somebody who's kind of seen a bunch of contracts, the level of involvement of the association in this hiring is just something you have not really seen before. And I understand there is a consent decree, I get that. But I think we've moved past that. I think we're at a level now where the chief can decide what the RFP process is going to be, what we're going to, the requirements that we need. And so our proposal is to strike this and kind of just to, I know when y'all provided your wage proposal, I think you said that the wages were priority 1, 2, and 3.
And 4.
4 and 5. and just to kind of highlight the level of importance on the city side is that this article is at least one of the top 3 priorities on the city side.
Well, it is a surprise, as always has been. There's a long history that you probably don't want to hear on this article, and I won't make you listen to it. But every one of these items was negotiated over many years at arm's length, with a lot of people weighing in, their experts and attorneys weighing in. some of this was a deal that was made to stop, basically to stop our opposition of the consent decree, which we'd probably still be in courts fighting about it today. We wouldn't have done that. And so we gave up a lot for this wording. It means it's very important to us. We'll review your proposal, but I'm just telling you that, you know, hiring and training are the reason you don't see it in other contracts is perhaps it's not as important to other labor associations. That is very important to us.
And you'll
Has
see
been over the years.
that we didn't take out the involvement of the training, so that's still.
Yeah, we'll look at it with clear eyes. And I'm just giving you a little bit of context. I mean, this is a very important article for us. Always has been. We spend a lot of time in Treasurer to make sure that good candidates get into the Austin, good, notorious, diverse candidates get in the Austin Fire Department. We can demonstrate that is what has occurred since our involvement's been here. And, you know.
Yeah, and I think the city's position would be that it obviously shares an interest in getting the best top quality candidates and them being trained to be in obviously one of the best fire departments in the state of Texas, if not the United States. So that's something that obviously the city wants as well. And the city feels that it can certainly do that without being restricted to specific language in a contract that actually may prevent other vendors from coming in and submitting proposals.
Yeah, I think that'd be an interesting conversation, but the professional criteria we put on there, I don't think is too arduous. It's just that a lot of people don't meet it. You know, have you done departments over 400 before? Seems reasonable. Have a vendor that's actually done bigger.
Yeah.
You know, so we'll take a look at it, but I mean, all this stuff was, again, discussed over and over and over. It was agreed on before. It's not like everybody didn't have an opportunity to weigh in, bring in their own experts,
Right.
and come up with it. So if a piece isn't working, you know, and a piece, I'm hearing you say it's not working, more vendors need to be able to apply. Well, I think we should be looking at that, but not striking entire parts of the document and taking away the ability for the fund associate to be a part of it. So we'll take a look
I
at it.
was gonna say, we'll provide a counter and we can have some additional discussion.
But that's your main interest, is that other vendors aren't able to compete?
I think the main interest is really that this is something that the administration, city administrator, the fire administration can do on their own without the need for having to put all of this in the contract. And if we need to vary here and there, we would like the flexibility to do so in the event that depending on the circumstances. So I understand, I guess I understand y'all's wanting to be involved. We completely understand. Obviously, these cadets are going to become firefighters that are going to be fighting right next to you. So, totally understand that. That's why we did not eliminate the training aspect. It's just the HPOC aspect.
Yeah.
So.
Well, we'll take a look. I mean, history would show us that the city has not been able to get a diverse process without this. If you look back on all of the processes before this, they were always huge, massive adverse impact. And that has changed since we started this process. So history would indicate management is not capable of doing it without.
Well,
now, maybe they've gotten better now, you know.
I think we would argue that
changed.
we have a new chief, that the city has been through the entire consent decree process along with you, and that they're just as capable of learning, and that they believe they have learned how to make this diverse, and that we're at the point where they can completely coordinate this on their own.
Well, that'd be a great discussion to
separate
have. I'd
efforts.
love to have the chief come and explain that to us, because we're pretty boned up on the area of the psychology. I'd love to hear his ideas and how he can keep validity at a decent level and reduce adverse impact, because the best experts in the nation from the DOJ could not figure that out. So I'd really be curious to see how Chief Baker's got that figured out.
Well, I don't think it's a matter of you and the chief having a debate on adverse impact.
I wanna hear his
I
ideas.
think it's the city's position that it's typically in every other contract at the prerogative of the department to do this. We have varied from it under the consent decree for a number of years, and we believe that it's now in the best interest of the city to put that back in the prerogative of the department.
We had this process before the consent decree. It was voted in 2009. And we are always open to making it better, and if an interest is to make sure we get more vendors, just take a look at that. If the chief's got some ideas on how we can increase validity or or keep validity the same and increase diversity, we would love to hear that. But the problem in the past has been the chiefs espouse ideas and don't really have a thought on it. And that's what was the problem before we got more involved. So if the chief wants to come in and say, hey, we got these ideas, let's run them. We got, you know, it's all math. We can run it through the industrial psychology. They can figure out if those ideas are going to work or not based on the data sets we have. But
Right.
just
And
saying that we're going to
is
give
that
him purview is hard to do.
I understand. Our position is that the city is capable of doing it without the association's input, and that they know how to hire experts, and that they know how to do the RFP process, and that it's been moving in the right direction now, and that they are capable of doing that. That's the city's position.
And our position has always been, and we'll take a look at this fresh eyes, is that then tell us what the ideas are, and let's put them in the contract. We don't want to, whenever we've given flexibility in the past, it's always had poor results. Doesn't mean that'll continue to happen, but it always had poor results. We would like not to just give flexibility, but have something that's substantive that we can put in the contract that we can weigh to see if it actually seems to be able to achieve that. Because we're on the hook too, you know, legally. You know, if we just give the chief flexibility, we're on the hook too.
So if this were written out of the contract, I think if you talk to Matt, you wouldn't be under liability for the chief's hiring. And I think what you're talking about, what I'm hearing at least, is that these portions have been in the contract since 2008. It is 2022.
Yeah.
It's 2022. So to presume that the city's never been able to do it before and can't do it now, it is a bit presumptuous. And to imply that you won't consider anything unless you hear exactly what his ideas are, I think is a bit presumptuous. I don't really hear that as a way to bargain, but I will tell you, we are coming in as the city position, just to make sure you've heard it, that the department is capable of doing this without the association.
It's always been the city's position, I understand that. And it was, you know, negotiated 2009, and of course it was refreshed a lot in 2015 under the consent decree. But we had some of the best experts of the nation come in and told us we can make this process better. And then after we ran through all the different numbers and all the different scenarios, they couldn't. So I'm really curious what the chief's ideas are and how to make it better. That's something we would need to hear. And if it makes sense, then it'd be more likely that we'd be able to get more flexibility. But just saying that we think we can do it is the history at the table with us on this particular topic doesn't lend us to saying, oh, that sounds okay. We'd like to hear what the ideas are, because it's not going to be easy to make it better.
Well, and if you'll see in the language, what the language does is it changes it to be similar to EMS and police. And the language mirrors that. And they've been having very good progress moving forward toward diversity. And this bear that out. And so, I mean, I think the city's really made great strides since 2009 with,
Sure have, yeah,
you know,
absolutely.
with input. So I think we need to continue to discuss, but I think we both know each other's positions.
And you may,
But we have a little more.
yeah, you may not be aware of this, but the association spends about $3,500 to $5,000 every process and runs the numbers, you know, so, and it gives them back to the city so the city can make some informed decisions. But we've been very good stewards in this process. And the reason we've done better since 2009 is because of some of the ideas we brought to the table. We were the people that brought the idea of using industrial psychology, you know, and using best practices in that field. And so if we can talk about how to hire more vendors, we can talk about, hey, we got this other idea that's not within the flexibility that's currently that can increase validity and or diversity. We're all ears. But saying that we're just going to give up flexibility because we think there's an idea that might work, that's something that's going to be much harder for us to agree to, just so you know.
Right, and I think it's more of an inherent typical management right that has been, you know, needled away over the years. And we understand why that originally started. But again, it's 2022. That started in 2009. So the comparisons back to 2009, to me, just don't even make sense anymore. It's 2022, pardon me, not 2002, 2022. I mean, that is a long time ago. And you know, we believe that that particular management right, it's been eroded away for years and years and years, to the point where that's an example of the vendor. That is a problem for sure. But that's an example of how much has been whittled away from the inherent management right to do so. That yes, it's in a bargaining agreement, we've agreed to it, we've worked with the consent decree, we've worked with the association over the years, but we are coming, to a new era, a new chief, a belief in the systems that are working for EMS and police, a belief in the city council who has that backed up by having people come in and review it, the Kroll report for police, where are we doing it wrong, where are we doing it right? And they're paying attention, and everybody's paying attention, the nation is paying attention. I mean, we believe that that's an inherent management right that we would really like to see back to management.
Well, I guess past agreements would disagree with that notion, because we had arm's length discussion where both people gave and took, and we ended up in equilibrium of the bargain and signed a deal. So for you to come back now and say that that history doesn't matter, we think it's an erosion of management rights, I would call reverse bargaining. And more important than what we call things is what we need to do going forward, right? And because we can both label things different ways, but to me, if your interest is not enough vendors are being hired, then we should look at that interest and see what we can do to make that better. If the chief literally, has some good ideas on how to make either validity better or diversity better or both, we would love to hear those ideas. But it's very unlikely that this side of the table is going to say that we're going to give absolute flexibility to the fire chief. Because it's been our experience, it's not a good thing, but what's also been our experience is a good thing to be a partner in this. The reason why we've had these increases in diversity is largely to do with the association's research and continual support of the program. And we have data right now that actually shows there's pretty big adverse impact in the sections of this process that the chief currently has absolute purview over. The multiple hurdle steps has a huge adverse impact. He has absolute purview over every single one of those steps. If anything, we would like to talk about that and how we can make that better. But we'd love to hear his ideas, but we don't want to hear, we just want more flexibility.
Well, I think we've stated more than that, but we do have further part of the proposal as well.
Okay.
Yeah, and I wouldn't characterize it as reverse bargaining either, because I think some of the issues that Devin had raised back in 2015 as something that was, hey, by adding all this stuff, it appears that we're favoring one vendor. And then lo and behold, here we are in 2022, and I think we've only used that one vendor for the
Let's look at that. I mean, that would be a good conversation. How do we expand the criteria so we get more vendors? That's a legitimate, I believe that's a good thing to talk about.
So just because we do have more of this article, benefit of the bargain, I believe this is something y'all have struck, and so we
Let's try to take all the consents that we said.
agreement out. Expedited contract agreements, also something we struck. Life of eligibility list. So here, notwithstanding the provisions of 143.025, will be in effect until the next eligibility list is finalized, however, not in excess of 36 months. So basically taking out no less than 12 months, no more than 24 months. I guess my understanding is that the list could be exhausted sooner than 12 months, and then I've been creating these lists is also expensive. So if we can keep a list a little longer until we exhaust it, I think this serves both parties. Same thing, a final eligibility list in existence on the expiration date of this agreement may continue to be used for a period of time, not in excess of 36 months. So that's a change that we need, not in excess. But the same language here, the duration of the list shall be specified in the notice to submit applications. That is not changed. This language is also we struck. Applies to certain provisions in the hiring article, only because we've taken out HPOC. Here, when it comes to the merger with an EDS, oh, you know what I didn't put in here? So, in y'all's proposal, there's reference to here,
The charter again.
there's reference to the charter again.
Yeah.
And so, of course, our position, we've already discussed at length.
Well, that's reference to chapter 117.
Yes, but in your last proposal on, I guess when we received Article 17 back in May, included striking out 174 and included language.
Oh, I didn't realize that.
Yeah.
I didn't remember that, let's put it that way.
So not including it here is our rejection of that language. So, internship program, so we have struck this out and included this language here. Also similar to what we have in police and EMS, the department may create and implement an internship program for individuals who are interested in becoming a firefighter. And we've also added any intern who successfully completes the internship program shall be granted 5 points on the composite score for the next eligibility list for hire as a cadet.
So it wouldn't be, it'd be an internship program, but it wouldn't put them in the department. They would still be going through the same selection procedures, they just get 5 points.
Correct.
Okay.
Yeah, and like for police, it puts them at the top of the list up to 38%, but we didn't do it the exact same way as police, we just added points to the composite score of 5 points.
Okay. Can I see that again real quick?
Sure.
I have one more quick question. Won't be a long one, I promise. The duration of the internship will be at least the equivalent of a one college semester. Okay, that's what I missed.
And obviously nowadays, a college semester with online help, so the equivalent could, be kind of,
So how would people be selected for the internship program?
that would be up to the department to create and implement that program.
Okay, and how does that not put us on the hook for a Title VII violation? We give the chief the ability to select who goes in an internship program that could possibly violate Title VII.
Why does that put you on the hook?
Yeah, that would put you on the department.
Because
is
we're
taking
giving them permission to do it, you can't do it without our permission.
Well, I think our position is that that's also something that it would be within the purview of the department and management rights in terms of the internship program. Y'all aren't necessarily we've chosen to bargain over it in the past, but
Well, the baseline civil service law, right, which
Right.
is not this. The baseline civil service law, and we're providing you permission to not do civil service law through a written contract. How are we not on the hook for a Title VII violation once we do that?
so you're saying that you're on the hook because we're bargaining over the fact that the department can implement
I believe
an
that
internship program.
that's why we're so cautious about, that's part of the reason why we're so cautious. We also like the benefit of the result, a good result, but, if we just say, hey, you can do whatever you want, you don't need to follow chapter 143 for hiring, which is very clear, general aptitude test,
Right.
1 year, we are given to a contract, we are negotiating around that baseline law, which is a state law. How does that not put us on the hook for a Title VII violation if we do not have any stipulation, but just give you the permission to do it, management do whatever they want?
Well, what this also says is that anyone admitted to the internship program is going to be the same process as applicants for the position of cadet.
Right.
So, I
My
mean,
question
that-
is, how do you select? Because when you select, you can violate, you can select and you can create an internship program that has a selection process that violates Title VII. So how are we going to select so we don't violate Title VII?
So I think we would say it's not our belief that it puts you on the hook, but we'll let you talk to your own attorney about that. We're not gonna give you legal advice on that, but we don't believe that that's true.
Okay.
Right.
But I guess, let's just say for the sake of this argument, it's not true. We're not on the hook. We still wouldn't want you to violate Title VII. We don't think it's a fair thing to do. How would you select people for an internship program without violating Title VII?
Well, we wouldn't want to violate Title VII either. I mean, that's certainly not anyone's goal or by any means, but we also feel like the screening and testing procedures that the chief and the department and administration can come up with are going to pass all that muster. So you're not necessarily going to be on the hook. At least that's not our position. But again, like Sarah said, you can also speak with Matt as to your
Internships, yeah, I mean, that's my concern. I guess internships imply that you're trying to select a certain group. And once you start selecting a certain group, and you make any race-based decision, then it can be a Title VII violation. So how do you do that? I mean, I would like to know. I don't have any idea how you would do that. You know, the other process, you put it out for everybody and then everybody comes in, so it's a fair process. When you start selecting certain people in an internship program, that, to me, creates a concern, a legal concern. How do you do that without making a race-based decision?
So we don't tell them how to do it within the constructs of the contract. We allow the department to do it under advice of the legal department.
I'm not sure we're comfortable with that, I guess is my initial first flush reaction. We need to look at it all and think about it.
Right, I hear that, and I think
Yeah.
that's probably the whole concept of this entire hiring article, is that we believe that the department is capable of taking advice from the legal department and getting input that's appropriate and learning from past, what has been happening over the last several years, and, you know, taking the consent decree, taking everything that's gone on and making solid judgments. And you may not be comfortable with that, but the city's position is that we are comfortable with allowing the department to make those determinations in conjunction with whatever legal advice they need from the city's legal
I
department.
think what we would say is that if they have the capability and they have the ideas, bring them here and let's put them in the contract. You know?
Understand your position.
Yeah.
Yeah. All right, so lateral entry, I think this local government code was added by Matt. Section C was also taken from the HPOC section and just pushed down here for the laterals. So, nothing really changed there. The chief may at his or discretion place candidates from the eligibility list who possess the correct certifications. Section D, since we made some changes to the eligibility, the light for the eligibility list in the previous section, we just sort of try to marry that up here in the new section D. The use of the word alternate instead of modified, for consistency reasons, the word alternate is already currently being used in the contract, so we've just made it consistent here. Cadet training, some added language, any applicant who cannot meet the minimum physical standards by day 1 of the training academy may be released without an option to defer rules. To a later class. Cadet training, as I said, the cadet oversight committee remains the same. We understand your interest in being involved in that. When we were going over y'all's proposal, we did see a comment from Matt as to maybe we should delete this language here. So the city's position is that we agree to delete that language.
Can you go?
Sure.
Read that real quick. And what's your opposition to this?
We don't have any opposition. Matt, you'll see our footnote. We agreed to the deletion of this language.
Oh, okay.
So, there we go. Agrees to this language should be deleted. That's, we're in agreement on that. So,
I think the whole section should be deleted. I don't think it- Is that important anymore? Because we don't need it like we used to. So we used to have these really strict standards. If you miss 2 tests, you'd be fired. You know, if you miss a retest, you'd be fired. So this was put in there to deal with that, but that's not part of it. We probably brought a lot more flexibility to the chief and the of training, the chief of the department on who they fire, who they terminate based on overall propensity of the entire record. I mean, to me, this whole section isn't needed at all because they already have that flexibility in other places. It's an artifact.
All of section 4 is what you're saying?
Section 4 could all be deleted
Okay. Can we move back up? We didn't point something out on the lateral.
because you already have that flexibility in other sections.
we'll take a closer
We'll take a look at it.
Yeah. Forget something.
Yeah. Go back up to lateral. fixed out there. In C, we just want to point out so that you're aware, if you go back to the very beginning, and I'm not asking Becky to do this, but I'll ask you to do this either in a minute so that you can see what we're talking about or on your own. Within here, it has embedded the language, at the top, this is an exception to the order of the eligibility list. So at the very top in D, where we have the ranking of the eligibility list, this is the exception to that. So I wanted to make sure that you noted that this is the section that we're talking about at the very beginning of the contract.
So so let me just make sure I understand it. So thanks for pointing it out, but I didn't really catch that. So if you want to do, this refers to alternate, or what you're calling the alternate process, right? So he's saying out of the one process, we could select alternate people that qualify for the alternate process out of order and pull them into a class.
Into the the normal class. If you take these people and put them into the normal class, then they can be ranked differently on the eligibility list in the normal ranking. There could be enough where this is its own class, which I think we would hope for at some point. But if they're put in the regular class, then they can be out of place, out of sequence, basically. I'm not saying that right. I'm not saying that right.
Maybe I'm just not hearing it right. It's probably.
No, it's,
Let me have you explain part of it.
it's that problem we have where we try to gather enough who could form the alternate class, but we have to go down beyond, say, the first two regular classes. And then we've had a legal issue with regard to their rights to the job for the regulars, because we're going over it. So this would just allow us to go down in and pull all the pre-certs and pull them into a class early in the process.
An alternate class?
Yes.
Okay.
Yes, a pre-cert class.
So you might hire the top 40 on the list, let's say, but the alternates might go up to 90 or 120 or something, and you'd want to capture that entire list and move them to
The
an
back of
alternate
it
class.
is they're gonna otherwise fall into the reach of the hiring eligibility. So if we have a list of 120, that's our total hiring eligibility list, we may go all the way through number 100 to pull the alternate class and then slowly do the regular classes down.
Okay, but you'd still cap the eligibility list at some level like we've done
None
in
of
the
them would
past.
score below the last of the regulars.
Yeah, so our intention is everybody eventually be given a job offer, but we want to pull these people first because they could be in this alternate class and get it done quicker.
And we can
Okay.
expedite getting them out of the.
Yeah, that's what we're doing. We'll have to look at it, but it doesn't
That's
sound
the
that
intent
obvious.
anyway.
That is it for that article, and that is it for our proposals and counter proposals.
So you're mostly leaving the training standards alone, but wanting more management rights in terms of hiring would be a quick synopsis.
Quick synopsis, yes.
You have proposals you're about to do now, and if so, could I have about 2 minutes?
I'm sorry?
I said, do you have proposals you're going to do now?
Yeah, we could.
If
That's what-
I was gonna say, could I have about 2 minutes before you do that?
Sure.
Just step out, have a quick.
Yeah. I'm getting queued up.
Yeah, we're thinking of
It's a printer.
They did print something up before.
Oh, okay.
But yeah, no, I agree, we need to. Just me? No, it's okay, go ahead. Do you know what date that initial information request was sent over?
Do I have what?
The date on the information request, just so I can find it easily. Like two-
Can I send you the information request?
Sure,
Yeah, I can just send it to you.
yeah, that's fine.
Yeah.
I have it
You
somewhere.
sent it 2 weeks ago today. It was on Monday.
Okay, I can find it.
You waiting on me or am I waiting on you?
What was he, Ben?
Okay.
Go ahead.
So this, I think, was your proposal. We just have some questions on it. And I think it goes along the same lines as what you're talking about in civil service. You're saying what we're adding kind of already contemplates ex parte communication, so we don't need the wording. And we're thinking, your statement at the table, and I think you agree with me, your statement was something, this doesn't change anything in amendment rights. Then our kind of question on that is, why add it? So, like, for instance, the word train, I mean, what do you mean by train?
If I may, Becky.
Go ahead.
I think the key portions here are the established, eliminate, or modify. So it's more the tense. The train, promote, demote, you know, we were just comparing and contrasting to various other collective bargaining agreements, and that was language that was common to others, so we put that in there. But the key, I think, is the tense, that we don't just decide, but we can establish, eliminate, or modify. And so I think, you know, with the rest of that, we're not as concerned about, except for that it's an ongoing right, in essence. So that was the key that we were looking for.
But what do you have now by putting this wording in you didn't have before?
A clarification that it's not just the right to decide job qualifications, because that might imply to someone that we can decide them, but then we can't change them throughout this contract. It certainly doesn't say that. That's certainly not current practice. But to say that we can establish job qualifications, we can eliminate job qualifications, or modify job qualifications, that, you know, the ongoing nature of it, I guess, is the difference.
So
So it's
then,
not different substantively, and it is what current practice is, but it's just a clarification.
okay,
Yeah, I think the word decide could be read as an outsider looking in, something different than what is the current practice and what is currently in existence, which is establish, eliminate, or modify.
And it's also the word determine, make, decide are kind of all used the same way, and they're not the same word. So it's just kind of a little bit all over the place in
it
this.
just seems to us like this has been an article, I think it's been around since 2005. And, you know, now we have a lot of words we're adding to it. That gives us some concern. And I think at the table you all said that, you know, this doesn't change anything.
Right, we're just trying to go along with best practices as far as language goes. You know, while we're in here, while we're getting into a new kind of era of bargaining with the new charter amendment, you know, everything needs to be crystal clear as it can be. So we were looking at best practices from other locations, and this we just thought was a better practice to have it clearly delineated. Because
So
we
that
don't think
sounds like
it's
it does
substantive
have some
changes it.
impact on this article, not that it doesn't. I mean,
I think it clarifies it.
clarifies it.
I don't think we've had an issue with what we're clarifying. I think it's just a best practice so that we don't have an issue moving forward.
Okay. So again, what do you mean by train? What when you say, right, to hire, train, what are we talking about there? You added that word, what are you clarifying?
Well, like we said when we were talking about Article 17, right? Obviously, what's in the CBA, so, you know, you've got state law, and then we've got the CBA, and then things that we're agreeing to, right? So, but management rights typically does allow for the chief to hire, train, promote, demote, discipline, suspend, or discharge in accordance with 143 and this agreement. So I think if you've got a little hesitance on the word train in there, the word and this agreement.
Well, I would ask that on every single word. Why are we putting the word in there? What does that mean to you? What does it imply? I mean,
Again, it's really just to memorialize existing principles that are already in place. And as you said, this contract or this article has been around since 2005. We're just following best practices in terms of keeping our articles, you know, up to date. You know, if a contract language around for 30 years may need some tweaking just to kind of move forward with the times.
yeah, I mean, that could be said, but it also could be said that words matter. When you change words in a contract, it could mean something. And just because you're clarifying something that you believe doesn't mean you're clarifying something that we believe. And I'm not sure why we would make this many changes to an article that's so important when you go into arbitration. It just seems like that could raise some variability, and you might raise some arguments to the arbitrator that we think are already settled. So it's concerning to us, I guess. That you're on one hand saying it doesn't really change much, but on the other hand, adding all these words. If it doesn't change much, then let's strike them all and go back to the original wording. Now, if it does change something, let's talk about what it changes. But that's our concern. So we don't have anything to propose right now. We just have that concern. So this one, this isn't the one I meant to bring up, sorry. Forget what you just saw.
It looked like you agreed to our proposal.
It's just wishful thinking.
At least you're honest.
Dues, so this is what I thought I heard, and if I didn't, you'll correct me. What I thought I heard is that indemnification wouldn't be as important if we weren't changing these categories, and we left them the same. And we haven't changed these categories in quite some time. We added the Hill Country Burn Fund a couple of years ago. Before that, all these things have stayed very static on our deduction form. And we're willing just to, I think above it says we can have 10. We're willing to stick with the 8 we have. We're willing to stick with these exact funds. Maybe we'll feel like that harms us in some way in the future, but it really hasn't been anything. There hasn't been MPTIS changes for some time. If that gives you some, help and not requiring an indemnification section, we're willing to do that. So, think about that. I'm sure you guys got to think about it. Get back to me unless you have a response now. That's fine too.
Hang on a second. Where you have miscellaneous, is that just like a space in the 3 underneath that are miscellaneous funds? Is that what that's intended?
No, we had an actual miscellaneous category. I left it in there. I thought you might want to discuss that, and that's fine. But we've always had it in there. I think we might have used it one time, but it does go a little bit against the thing of keeping static, and so we're willing to talk about that. It's just that has been in there, so I just left it in there and wanted to discuss it.
So, just because I'm looking at our proposal, this for the benevolent paragraph, and then the very end of that sentence, if authority has been given to the association by the employee, either through written agreement or bylaws of the association. That was language that we added as part
For the benevolent fund?
for
or
the
sorry,
benevolent
yeah.
fund.
That was wording that,
Y'all
was been in the, no, it's previous wording, I'm pretty
No,
sure.
the last part of it we had.
That last part of it, if the authority has been given, so it used to say change, period. Our proposal, if the authority has been given to the association by the employee, either through written agreement or bylaws of the association, is language we added in. And I just want to understand why we have you here. Does this mean you agreed to it or not?
I didn't realize that was new language. That's my bad.
You
So I'll
got
have to
this
look at
from
that.
Matt.
He accepted it, and we're gonna hold you to it, don't you? So I pulled ours up if you wanted to see that.
Let me look at that, please. Let me just take a look at that real quick, the old contract. I mean, I'm sure you're right, but I'm just not recalling.
I don't want there to be any confusion.
Oh, you did add something to it. Some of the wording was still there. It was just a little bit
Yeah.
added to it. Okay.
For the at the end. Yes.
Okay. All right, now I kind of got my bearings. Let's go back. Okay, now I'm on the same page.
You need to make your point.
So giving the city 3 pay periods in advance for a change of authority has been given to the associated by employee either through a written agreement or bylaw of the Constitution. And I think that's fine, but let's talk about that. So what we normally would do is we might change dues. And we have a section of our Constitution where we have, and actually it's governed by federal law. We got to send out written notification 30 days in advance. And you have to have a discussion, you have to have a legitimate vote, and all that sort of thing. And at the end of that, we take that vote and we package that up to payroll, and we tell them, hey, we need to change it based on this vote. And then they change that amount, and we give them whatever time they need. If they need 3 pay periods, that sounds very reasonable. So that would satisfy everything that we're agreeing to there, correct?
Well, it depends. You need to continue going down, because I think you may have misunderstood our indemnity comments.
What's that?
I said, it depends. You need to keep going down, because I think you may have misunderstood our indemnity comments.
Well, we're wanting to strike the indemnity comment.
No, I understand, but I think what you said a minute ago was since we've listed all of these, that would take away our concern. And that doesn't take away what our concern was. Our concern was if you go right back up to where you were, is that's great. You tell payroll, hey, we've abided by our bylaws and our members agreed to this, whatever. We're just saying that's on you then. That's the part we were saying, if you don't want to change these, if you don't want to have the authority to change it, that's what would need to go away for us to not want the indemnity. Because this is us saying, okay, thanks, Bob, we'll do that. You know, we'll take your word that it's in your bylaws. We're not gonna go review your bylaws. We're not gonna review any written agreement you have with your employee. You know, that's with your member. That's on you. You're telling us, me, payroll, go ahead and deduct this one instead of that one, or go ahead and raise these dues or lower these dues. That's on you. And if you tell us to do that, that's fine. But if there's a mess up there, then it's on you. That's the indemnification we're looking for.
Okay, so what you described to me was a member bringing suit against the association because we changed their dues and maybe they don't feel like we did.
Yeah, and I think the example we were using was the EMS and cleat situation.
Yeah.
And where, you know, if a member comes to the city and says, I didn't give you authority to take cleat off my, you know, whatever. It's like, well, we have written authorization from the association. That's the point where we're saying, don't put that on us. We're doing you a favor here. You know, it's a bargain for a favor, but you know, we can't, we're not gonna control
if we keep
that.
them
We're
all
gonna
the
let
same,
you
we've
control
taken
that.
out whether it goes to cleat or something else above, but what you're also saying is if we raise it or lower it, a member could say, we don't think it was done appropriately, and they may try to file a lawsuit.
Against us.
And you think, so
Yes.
if we limited the indemnification to just that,
Mhm.
then we'll probably be okay with it.
Yeah.
But this is a little broader than that, the way it's written.
Yeah,
makes
that's what we were
sense.
talking about, however, so we can,
Okay,
I think,
all right, that's helpful. The other part is, you know, I'm kind of adamant about this, the information request. We've done this for years. It seems like anytime you have a contract, like for instance, the hiring vendor we're just talking about. The hiring vendor, you're under contract, they need information, you don't make them file a PIR. It's ridiculous. We would never do that because it's a terrible way to do business. So we have a recurring, responsibility between payroll and providing them information and providing us the deductions. It's a business relationship. It's absurd that we would have to file a PIR if we're trying to resolve a difference between what we're getting and what we took out. That is inefficient and it's ridiculous. We've always done it the other way. Then most recently they started making us do a PIR request. We don't want to do that. It doesn't satisfy anybody's interest or doesn't help in any way in business efficiency. We're doing a contract. We want to be able to say in that contract the same way any other vendor would get information from the city, we could get it too. We shouldn't have to wait for 10 days. The problem with the PIR request, and I had this problem with y'all recently, is it's very one way. So I put in a request, I don't say it quite right. I don't know exactly what I'm asking for, but I know the concept, because I can't talk to anybody, right? So now, they say we don't have it. And so I gotta try to think about what I didn't do right and ask another request, and they said you have the stuff you want. You know, that's not a very efficient way to do business. Now, it is the way a normal citizen would do business when they request public information. This is in the context of an agreement on a recurring business activity that we're doing every 2 weeks. We need the flexibility to be able to resolve those things in a timely manner.
so what I'm hearing you say, I think can be resolved maybe in a different way. Maybe if instead of generalizing this to any information to determine the accuracy of a payroll deduction can be requested, meaning you're calling up and requesting it each time. What I thought I heard you say during the last session or the time before was maybe, and payroll will provide a copy once a month, just something written into the contract that isn't a request, but a standing order basically. That already has pre-redacted whatever information you have, that may take them a longer period of time. And I don't know that that would be okay, but that might be a different approach than kind of this generalized, way it is, because I think I heard you say something differently, like we're already getting this on a bi-weekly or a monthly basis, or I don't know exactly what it was that you get or what you need.
Well, I think
but-
Tim could, if he doesn't mind, he explained it last time, I think he explained it again, what the problem is, and I think it's something we can fix, you know. If you
So
don't mind.
basically what will happen is in some payrolls, someone doesn't have their dues deducted, and it could be for any reason. It could be for leave, for a suspension, or it could be even that they've turned in a sheet that says they don't want to get the dues deduction anymore. I don't have preview to getting that format to see if it was filed or not with the city of payroll. So I just need to know that that was done and what was the case. Like, I don't need to know the details of why are they on leave or whatever. I just need to know this person's just on leave for now, so he's not going to have the dues deduction. Don't worry about it. That was correct. Because there have been times where something's been deducted when it shouldn't have been, and later on it gets corrected. And so if we get calls from our members, we need to know what's going on.
Yes, he's reconciling the list, and he's finding differences, and he wants to be able to resolve those differences, you know, by calling somebody and getting it done quickly. They can schedule a time to do it, it's fine, you know. But to do a PIR request to do that just doesn't even make walking around sense.
And it was a couple of years ago, but it was as simple as just calling like Judy or Jenny and just saying, hey, I have these 3 people that didn't have deducted, and you just let me know what their status is, and they would just say suspended, leave without pay, whatever, and that's all I needed to know.
Okay, so instead of individually requesting that, is there a report that you could request?
I can do a PIR. The issue is that what Bob's saying, half the time I get returned because it says I'm not doing it properly.
What-
You're
That's
suggesting
not
having
what
that
it is.
report come to them on a recurring basis.
Automatically, currently, and that way we can find out if there's any concerns from the legal department on whether or not, well, we think it's confidential, whether or not they give to pipes and drums. You know, I don't know the exact rationale for all of the changes in policy, but if you can think and had a word, a standing report that we could put into the contract, then we can see if there's an issue, if that makes sense. Because I think that would be easier than just having kind of a random, we can not do a PIR, because we don't always know what the request is gonna be.
I understand what you're saying. So
So,
Tim, would
yeah,
that help,
if we can-
or do you need more detail? You need to know why it's not on the list, right? Not just that it's not on the list.
Yeah.
So I don't think they have a list that says this one isn't on there because of this reason. If they do, that'd be great, but I bet they don't. And so he's trying to reconcile, why was this on this time and not this time? He's just making a call saying, hey, on person X, I show a difference on my report. You have a reason. I mean, that's what we're trying to fix
Yeah,
here.
and I have no idea whether a standing request to show, you know, number and amounts of payroll changes would be confidential. You know, but if he could get a report that said there were 7 changes in the last quarter and a total amount of $53.72 or whatever, he could reconcile it knowing, yeah, they have something. Or if he could get more than that or less than that, I don't know. But I don't know what he really needs to reconcile the situation. And I think just a blanket, all PIRs are kind of waived when it comes to payroll deductions is a bit much. So maybe we could put something in the contract while we're here and say, you know, payroll will automatically spit out this report every so often that includes X, Y, and Z. And maybe they can do it, maybe they can't. You know, I know there's redaction information on certain things, and I don't know how hard it is, but if they have to do it once, you know, maybe it's easier to do once instead of a program to do it than to, you know, every time have to recreate the wheel. You know, I don't know, maybe I'm making it worse.
Maybe
maybe not.
they don't even care, you know? I mean, did anybody ever bother to ask payroll if they even care? I mean, maybe they're fine with Tim calling them occasionally. What is it? Maybe every other
Every
month or
pay
something?
Well, I think it's not payroll per se, I think it's payroll in conjunction with legal and the open records request division. Because they also get requests for PIRs. You know, how many PIRs did you get in relation to payroll or in relation to,
Right.
and there's, you know, just random groups are out there trying to figure out whatever they're figuring out. And if they don't have a way of keeping track of that, that's another issue. So I don't think it's just payroll saying, oh, I'm too busy. But everything that goes out of payroll to somebody else has to be cleared through legal to make sure that they're not accidentally giving out any personal information that they can't give out.
Okay, well, I think we certainly can't break the law, right? We don't want to, but we're not talking about a bunch of different payroll, because it's talking about accuracy for the deduction.
Understood, and that's why I'm saying if you tell us the exact information that would help, that on a report that could consistently go out versus a pick up the phone call.
So we're saying information required by AFA to determine the accuracy of a payroll deduction. That's not personal information.
Well, it depends, and I'm not saying that, I'm not saying this, I don't know whether or not legal would say which of these they're giving to is their private business, and you can't find that out. Maybe you can, maybe you can't, I don't know, I'm not in the legal department determining what appropriate PIRs are. But if it's a matter of, was it a change in the association dues, was it a change in the individual members? I just don't know. It, like he said, is it because they're out on HIPAA leave that we can't confirm, and he's not asking why? If that's, I don't know the exact situation in each of these, and that's not just one situation. Some of them could be HIPAA related, some of them could be actual deduction forms. So, it just kind of depends, and that's just kind of a, for a general PIR to be waived completely, it is something that the city changed their entire policy on. But if in a contract it says, and the union will be provided a report that includes X, Y, and Z, that's different than a PIR. So to me, that's just a workaround that might be easier if you can figure out a way to ask it.
Yeah, now if we get a report that does all that, which I doubt, that'd be great. That'd be the ideal, right?
Right.
And I really doubt that's gonna be the case. So again, determining the accuracy of the payroll report does not compel the city to relay HIPAA information violations to us. It absolutely doesn't. It just says we need information to determine the accuracy of a particular deduction, right? They don't have to tell us anything further than that.
But the example he used was if somebody's out on that leave, and that's why they're not paying their payroll deduction, or,
They wouldn't have to say they're out on a particular type of leave. They could just say that they don't have a payroll record for this period. That's why I wasn't taken.
I understand, and that's what he's saying, but it's not always the same circumstance.
It's not
It's not always the same circumstance. And I'm not presuming to know that there aren't circumstances that could be a violation. That's what I'm saying, I don't know. So if we can get this honed in more to, instead of just saying, we're gonna skip a PIR, and say, can we get a formal report on payroll deduction changes that includes X, Y, and Z that would allow him to reconcile without trying to waive a PIR? That might be an easier answer.
So what's our pathway forward? Do we need to put in a PIR to ask payroll if they got a report that will satisfy this, or can you guys research that for us?
I expect that they would have to create a report to do so.
Okay.
That's not the question. The question is a report creatable that doesn't violate legal's interpretation
That'd be ideal. Yeah, we
of
get
what
that.
can be just automatically spit out with X, Y, and Z automatically redacted. Would it cost for payroll to do it? Sure, but if it's in the contract, then they would
imagine.
get it done.
Development costs might
If
be high, but
possible.
that's
So,
that. Thank you very much.
yeah,
Okay,
I
so
think
y'all
it would
gonna
be
look into that for us, or?
Well, I think we need a little more, and maybe you can tell us, what you've needed in the past, couple of years.
Okay, well, it sounds like it's possibly solvable then.
Yeah, maybe not, but I'm just thinking that's kind of a workaround.
But just really briefly, we'll get off this article. And putting these in order and saying we're only gonna do these is helpful to your side, is that correct or not?
Absent that miscellaneous one.
You think what?
Absent the miscellaneous.
Besides the miscellaneous, yeah.
That's,
Yes? Because we don't have to do that. We're offering next, we thought that meant your interest.
I don't think, our anticipation was not really even that it has to per se be in the contract, but that it's up to the association, and the same with what did you do with the 5 free ones?
You asked for 6.
Which one?
They go down to, scroll down a little bit more.
Oh, we added 6
6.
instead of 5. I think that's what you're talking about.
Okay, I see. So as long as those are pre-listed in the above,
They are.
okay, then I guess listing them there would be easier.
Okay.
Yeah, because we do have them.
Yeah, I could put an asterisk by the ones that are not deducted for the 10 cents.
Well,
They're all
see,
of the
this
compounds.
portion this portion, I'm presuming the association informs payroll of what these 6 are. That's between you and them. We don't, there's just a flat number. You don't have to tell us, you don't have to list it in the contract. You know, that's your discretion. We just have a number and you can determine which those are and let payroll know. what
Okay,
those
well,
deductions
you
are.
guys said 5, we're saying 6, are you guys?
I'm not saying that, but conceptually what we're talking about is that you would give those to them.
Okay.
We'll certainly consider 6, but I can't promise you that.
I think we can put this one to bed, then we're pretty close. We just need to find out about that report, and I think we're, beyond that, we're pretty close, I think. So. On Article 23, cadets, we've gone back and forth on that one, and we don't want this to look like reverse bargaining, I don't think it is. We would just like to go back to the original wording and just agree to disagree. We thought we could get a little further on that, but it doesn't look like we're going to. And I applaud y'all for trying, but this doesn't seem like it's making it any easier. So if it's okay, we could just go back to original wording on cadets, unless you guys feel differently.
We'll chat about that in caucus. You know, the other part of that is we weren't sure that we had ever formally laid out why we thought the way we did to you. You know, we kept saying, well, we've analyzed it, we think this, you analyzed it, you think, we agree to disagree, but we didn't know how in-depth those conversations had gone in the past as to where our rabbit hole went to and wound up and exactly how we got there. So we wanted to make sure that you at least had an opportunity to follow our trail.
Right.
And if you disagree still, then we'll consider looking at the old language again and we'll chat about that. But we
We're
wanted to
fine with
make sure
talking
you
about it further. We're just saying that we're also fine with going back to the original language.
Okay.
But it's kind of in your court. You guys decide what you want to do.
Okay.
If our proposal's going back to original language. If y'all think that the conversation is fruitful to continue, we'll continue with that conversation. Entire agreement. Oops, sorry.
Was that 26?
We put a lot of the language back that you guys, that y'all had before in original language and added the part that acknowledge that their duty to part collectively in good faith. Under chapter 174 continues during the term of this agreement with respect to mandatory subject of bargaining not covered by this agreement. Because remember our concern was.
You put the language back in and added some additional.
Yes, and I think the concern we were addressing with y'all, I'm not sure this satisfies it entirely. Our concern was that the language said that we were going to agree that we're not going to negotiate things we didn't even know existed. I understand if you don't know it because you didn't research, that's another category of not knowing, but things that we both don't know. It's kind of what it said before, and that was our concern. And I think our concern was actually more elevated than our attorney's concern was, the more I talked to him about it. So this was Matt's suggestion to try to satisfy that, putting your language back and just making it clear that mandatory subject of bargaining need to be negotiated.
We'll take a look at that.
Yeah.
I think, and Matt's not here, but I think what he's just saying is that we agree that impact bargaining exists. And I don't know why everybody is shying away from that term. I mean, that's a nationally recognized term. I think that's what he's trying to say, but he's not saying it. So I'm not sure that's what he's trying to say.
Well, he'll review your comment table.
Perfect.
I'll get you his opinion.
You know, actually, I would like that, I think, before we're able to consider
Yeah.
this. I think that's all he's trying to say.
I'll get back to you on that.
Perfect.
Okay, and the last thing's maintenance standards. No, I see, I got some for EMS too, sorry. So maintenance standards, you recommended putting in this pretty common, I guess you'd say legal standard for past practice. Is that the way you'd say it? Okay. And there's other ones, but this one certainly is commonly used. And the only question we really had is how unequivocal is unequivocal? You know, for instance, you know, we had this, now maybe we just have to argue that from the arbitrator, right? But
And that's actually what that last sentence is determined to me. We set the standards, the arbitrator still gets to retain the authority to determine that, whether or not it's unequivocal.
Sure, and I figured that's where we argue. I just wonder what y'all think, and I just want to give you this example. So, you know, like on the dispatch schedule, it's been around since the mid-70s, and it's been a modified 2472, but there's been changes made to it within the context of a, you know, 2472, probably, I don't know how many times, but I think you probably made something, you were there, and other people make it, but they still stay within that. So we would look at that as a past practice. Is that unequivocal? I mean, what's your, I mean,
I
obviously
have no
minor
take on
changes.
that. I don't have enough knowledge to.
So you just think it'd be something the arbitrator would need to,
Yeah.
need to make our case.
Yeah,
as
you
the
still put
arbitrator.
evidence on the table
And
as
they
to
would
whether or
decide.
not it's
Right.
unequivocal.
Okay.
Right, and that's the thing, is that both sides are gonna make their arguments, and they're gonna say why it's unequivocal, or why it's this, or why it's that. But the arbitrator will at least have a standard to follow, as opposed to just some willy-nilly, and I've seen arbitrators not follow a specific standard, which we want them to follow a
I
standard.
think putting standard is good in a lot of ways. I just had that question, and I think you've answered it. It's really, we would make our case to the arbitrator.
And just like clearly articulated and acted upon, we would argue why it is or isn't, you would argue why it is or isn't, and the arbitrator would make that decision at the end of the day.
Okay. Fair
But
enough.
at least we know what the issues are and what we would be arguing for, as opposed to just kind of the Wild West.
But in the case, the example I put out, you wouldn't want to comment on that, because basically what we want to do is let the arbitrator decide. I don't want to put words in your mouth.
Yeah,
I mean,
I don't know
I
enough
think
information.
as
on it.
attorneys, I've realized
Yeah.
attorneys can argue both sides of the issue pretty easily if they want to. But, which is a good thing, right?
I heard Bob can argue both sides of the issues.
So, yeah.
I don't have to train with all that. That's much better training. And in 31, I suspect you won't like this. But, and I'm going to show it to you, but I'm also going to go back and with the information we exchanged today on your interest of keeping binding arbitration language out. We're going to review this, but since we got this written, I'll put it up anyway. This is what I think. This I don't expect to say yes. What we were trying to do is meet your interest and say that the arbitrator would only have ruling over the fire department issues and nothing to do with the EMS, what we're trying to capture there. Which I don't think it's all your interest, but I know that was a sub-interest you were expressing.
Yeah, I would say that's one of the three major issues that we were concerned about, you know, the.
So we got 1 of 3.
One
That's
of
good.
three. One of
We don't usually get that many, so it's a big success for us. But I already know that we need to talk about what we learned today through that exchange of binding arbitration wording. So I just thought I'd show it to you, so we did some work on it. We did some work. There it is. That's all we have, right? That's all we have to present right now. And I don't know that we can say anything over to you. I still need to think about management rights a little bit more. Our attorneys are reviewing the exchange we had today. The dues, I think there's a little research you've offered to do on seeing if we can get a report like that. And we're going to be looking at trying to limit the scope of the indemnification what we discussed at the table. On 23, we're fine with going to original wording. It sounds like y'all might think about that some, because there's some discussions you may want to continue on that. That's fine. We'll leave it at your side of the table to decide that. On the entire agreement, the new wording from Matt, we're going to have Matt review the conversation we had on that. Same with maintenance standards, although I don't think it sounds unreasonable the way you stated it. We want an attorney to review it. And then 31, we just showed it to you, but I think we're going to have to do some more thought on how we approach arbitration language based on our most recent exchanges.
We will send you 8, 11, 17, 28, 30, and 31. And take take a look at 28 specifically maybe first, because I think we're probably pretty close to
Okay.
a TA on that.
Yeah, I bet we are.
And I will follow up on your information request from a couple of weeks ago.
Okay, thank you. That was easy.
We won't have any additional
I
articles.
don't think we'll have anything additional this afternoon as far as further responses.
Could I get with you? I mean, you guys just hang around for a little bit though?
Yeah.
I mean, could I kind of see what we may have planned for this afternoon? I'm not sure.
Yeah.
Sure.
We just haven't discussed that yet. So.
Nope, that's fine.
We'll take a lunch break.
Thank you.